But maybe put most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding, and it's true, I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck, the first mover state here, Colorado, we're stuck with that record. And, I don't want to get into whether the record, I mean, maybe the record is great, but what if the record wasn't? I mean, what if it wasn't a fulsome record? What if, the hearsay rules are, one-offs? Or what if this is just made by the Secretary of State without much process at all? How do we review those factual findings? Why should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making, that we made with Mr. Mitchell, too, that it just doesn't seem like a state call?
3 points, Your Honor. The first is that ordinarily, of course, this court reviews factual findings for clear error, but President Trump made the point in his reply brief that sometimes on constitutional questions that require a uniform resolution, this court can do something more like a Bose Corp-style independent review of the factual record. And we would have no objection to that, given that the record here, really the facts that are disputed here are incredibly narrow. The essence of our case is President Trump's own statements that he made in public view for all to see.
But then that's saying that in this context, which is very high stakes, if we review the facts essentially de novo, you want us all to just watch the video of the ellipse and then make a decision without any deference to or guidance from lower court fact-finding? That's unusual.
Well, ultimately, President Trump himself urges this court to decide the merits of his eligibility on the factual record here at page 2 of his brief. He's never at any point in this proceeding suggested there was something else that needed to be in the factual record, any other witnesses that he wanted to call to present his case. And again, the essence of our case is his own statements, and in particular, his own videotaped statements on the ellipse.